you can't use a gun for self-protection in Canada.
Hey everybody, I hope you're having a great day. I came across this video on my feed the other day, and I thought it would be responsible to clear up a common misconception before somebody gets killed. I'll be talking about just how dangerous this is and why it's dangerous at the end of the video, so you're going to want to stick around. But first, let's take a look at the video that I'm referring to.
Do you as a Canadian citizen have a right to defend yourself?
Yeah, right?
Yeah.
Definitely. So I would say yes.
I have no idea. With my arms?
Do you as a Canadian citizen have the right to defend yourself?
Definitely.
Yeah.
I think yes, I do have the right.
I think the answer is no, but it should be yes.
Actually, according to Canadian law, you don't.
Oh, yeah?
Yeah.
I don't? So
No.
what do I do? Nothing?
Well, you have to call the police and wait for them to show up.
Oh well.
What? Oh, I call the police? And I tell him to wait the police to come?
Yes.
And do nothing while I'm waiting for the police?
Yes.
Oh. Oh my god, I didn't know that.
I'm really shocked to know that.
Yeah. I know, it's kind of crazy.
Yes.
You can't even, you touch them and it's assault and you can be charged.
Even though they're in my house.
Yeah.
And they aim to attack.
Yeah?
Yeah.
I can do nothing?
Nothing.
My god, that's not fair.
But you should have rights, that's it.
Yes, definitely.
Yeah.
Some of you may not know my background, but it's kind of important to this video, so I'll tell you again if you don't know. I'm a retired RCMP member. I spent 33 and a half years in the RCMP with another year and a bit in other policing in Canada. I'm not a lawyer. I didn't go to law school, but I do have a degree in criminology. So I do have a little bit of knowledge on this subject. That being said, I'm not going to give you any legal advice here. All I can tell you is what I believe and what I would do, so keep that in mind. Now, I'm not going to question her motives. I'm sure they're pure, or at least I hope they are. However, she's just wrong, and the information she's giving is quite dangerous. I'll discuss the danger of this in just a little bit, so stick around. Self-defense is, in fact, a natural right, so even if it wasn't codified in the criminal code, you would still have that right. It's inalienable. You have it because you exist. Second, the criminal code clearly states that you have the right to defend yourself, someone else, or your property, and you can use a reasonable amount of force in that defense of property or person. I'm going to read here directly from the criminal code, and I'll put it up on the screen as well. Section 34, subsection 1 of the criminal code reads, "A person is not guilty of an offense if A. They believe on reasonable grounds that force is being used against them or another person, or that a threat of force is being made against them or another person. B. The act that constitutes the offense is committed for the purpose of defending or protecting themselves or the other person from that use or threat of force. And C. The act committed is reasonable in the circumstances." So, was how they reacted to that force reasonable? Subsection 2. In determining whether the act committed is reasonable in the circumstances, the court shall consider the relevant circumstances of the person, the other parties, and the act, including but not limited to the following factors: the nature of the force or threat, the extent to which the use of force was imminent, and whether there were other means available to respond to the potential use of force, the person's role in the incident. What they're talking about here is whether or not you were a pure victim, like where do you stand in this? Were you an actual victim, or was something else going on? Whether any party to the incident used or threatened to use a weapon. The size, age, gender, and physical capabilities of the parties to the incident. The nature, duration, and history of any relationship between the parties to the incident, including any prior use or threat of force, and the nature of that force or threat. Any history of interaction or communication between the parties to the incident. The nature and proportionality of the person's response to the use or threat of force, and whether the act committed was in response to a use or threat of force that the person knew was lawful. Subsection 3. Subsection 1 does not apply if force is used or threatened by another person for the purpose of doing something that they are required or authorized by law to do in the administration or enforcement of law, unless the person who commits the act that constitutes the offense believes on reasonable grounds that the other person is acting lawfully. So you cannot resist arrest, you can't resist lawful authority. They qualify that by saying, unless you didn't believe or you believed that it was unlawful. But here is a bit of sage advice. If you're being arrested, even if you think that it is an unlawful arrest, don't resist. Resisting will not end well. Go along with it. You can deal with the lawfulness of the arrest later, but do not resist the police. Do not fight. That's just my advice. Now, you can choose to ignore it. And again, I'm not a lawyer, but my advice is, as a police officer, or having been a police officer, don't resist the police. It will not end well. So what about defense of property? Here again, I'm going to read directly from the code. Section 35, subsection 1. A person is not guilty of an offense if they either believe on reasonable grounds that they are in peaceable possession of property, or are acting under the authority of or lawfully assisting a person whom they believe on reasonable grounds is in peaceable possession of property. They believe on reasonable grounds that another person is about to enter, is entering, or has entered the property without being entitled by law to do so, is about to take the property, is doing so or has just done so, or is about to damage or destroy the property or make inoperative, or is doing so. Paragraph C. The act that constitutes the offense is committed for the purpose of preventing the other person from entering the property or removing that person from the property, or preventing the other person from taking, damaging, or destroying the property, or from making it inoperable or retaking the property from that person, and the act committed was reasonable in the circumstances. Subsection 2. Subsection 1 does not apply if the person who believes on reasonable probable grounds that they are, or who is believed on reasonable probable grounds to be, in peaceable possession of the property does not have a claim or right to it, and the other person is entitled to its possession by law. You may have heard about all these squatters in the United States. This part of the code may actually cover you for removing them if it were to happen in Canada. But again, I'm not a lawyer. I can't give you advice on that. But that's how it reads to me. Subsection 3. Subsection 1 does not apply if the other person is doing something that they are required or authorized by law to do in the administration or enforcement of the law, unless the person who commits the act that constitutes the offense believes on reasonable grounds that the other person is acting unlawfully. So to reiterate, don't resist the police. And if somebody is coming to repossess your property, and you know that they are repossessing your property due to non-payment, don't think that you have the right to assault them or to use force against them. So self-defense in Canada is a reverse onus offense. That means that it is your obligation, if you are claiming self-defense, to be able to prove it, and to be able to prove it in a court of law. So you need to be able to justify your use of force and the level of force that you used. You do not have to measure the exact amount of force you used with exactitude. That has been established by the courts in Canada, unless it's changed since I've left the RCMP. Unfortunately, in my opinion, the administration of justice in Canada, the courts and whatnot, are managed horribly. And as a result, there are many people who are charged, even though there is clear evidence of self-defense. And they're forced to go to trial in order to prove themselves innocent. Although I do agree that there should be some onus on the person claiming self-defense to prove it, oftentimes some really horrible Crown counsels have in their mind decided that it is in the best interest of the public, especially if a death was involved, that the determination of self-defense be made in a court of law. So what happens is a lot of innocent people are charged and have to go through the stress and the expense of a trial in order to prove their innocence. To me, that feels like a miscarriage of justice. And as a result, many innocent people plead guilty to avoid that stress and that expense. So what about carrying a weapon for self-defense? Well, that's covered under the section of the code that refers to the possession of a weapon that is dangerous to the public peace. I'm going to read that directly from the code as well. Section 88, subsection 1. Every person commits an offense who carries or possesses a weapon or imitation of a weapon or prohibited device or any ammunition or prohibited ammunition for a purpose dangerous to the public peace or for the purpose of committing an offense. Every person who commits an offense under subsection 1 is guilty of an indictable offense and liable to imprisonment for a term not exceeding 10 years, or is guilty of an offense punishable on summary conviction. Now that sounds pretty straightforward and you would think pretty reasonable, but the application of this section actually causes me a little bit of concern here. I personally believe that if you're carrying a weapon for self-defense, that it is not dangerous to the public peace, and obviously you're not intending to use it in a criminal offense. But I'm in the minority here. The application of this section is often used to disarm and charge people when it may not be appropriate, in my view. Having said that, it has been ruled that a weapon of convenience is appropriate for use. That means that if somebody breaks into your house and you grab a stool or a chair or a kitchen knife to defend yourself, that you may be covered. Again, I'm not a lawyer and I'm not giving you advice, but from my experience and from the rulings I've read and have been told about in the courts, that's how I read this. So again, I'm not giving you advice here. I can only tell you what I would do. If somebody was breaking into my house and I felt that I was threatened, I would be perfectly comfortable, if I could, get to my firearms, to employ my firearm as a method of self-defense. However, I understand that I would be required to justify that action in court. So in the beginning of this video, I said that the information that young lady was given was dangerous. And I told you I would explain why. So how is it dangerous? I want to preface this by saying that for 2 years while I was in the RCMP, I did police human resource studies. Those police human resource studies were designed to tell detachment commanders how many constables they needed. The bulk of that was evaluating workload and response times. And I can tell you that the goal of a city police force, and this is only a goal, is to respond to priority 1 calls. That's calls of serious crimes in process, to be done within 7 minutes. So they want to respond within 7 minutes of getting that call. A lot can happen within 7 minutes. So if somebody is threatening you, maybe breaking into your house, maybe they have a firearm or a weapon with them, maybe they're twice your size and they're threatening you, and you feel that just calling the police and waiting, and you're not going to take any other action, you're not going to take any move to arm yourself, you may just find that that is insufficient to keep yourself safe. Again, I'm not a lawyer, I'm not giving you advice, but I personally would not count on not being harmed within that 7 minutes. I would take positive action to protect myself, my family, anybody else, even my property, if I felt I could do so. But that's what I would do. What would you do? Let me know in the comments below. Hey everybody, don't click away just yet. As you can see over here, we have a QR code. If you follow that code, it will bring you to a petition that I have started to encourage Mary Simon, the Governor General, to do her job, dissolve Parliament, and call an early election. There's also a link in the description below and in the pinned comment. While you're down there, I encourage you to leave a comment. I do read them all, and I try to respond to them all as well. And if you've enjoyed this video, please click the like button and share with your friends. Up here in the corner, you will find a soaring eagle. If you would like to subscribe to the channel, all you have to do is click on that, and it will bring you to my page. And over here, YouTube has suggested a few videos that they think that you will like. I appreciate your support. Hope you have a great day, and we'll see you on the next video.